OpenAI just released on August 5 two open-weight model called GPT OSS under the Apache 2.0 license. So today I break down what open-weight means compared to open source, and then we break down what the key legal terms are for the Apache 2.0 license that every developer and businesses should know about. So what's the difference between open-weight and open source? Simply put, it's about what's being made available under the license. With this release, OpenAI provided the weights of two pre-trained large language models. You can think of these weights as the core parameters that the model have learned during its training. Developers can download those weights and then fine-tune and improve them so it can fit their application's needs. Now, open source, on the other hand, as the name suggests, involves typically the release of the source code of the software. This allows the developers to see, modify, or improve the underlying code of the software being released. This distinction is technically important, but ultimately both approaches do improve the democratic access to AI. But now these open-weight models are released under the Apache 2.0 license. This is a very permissive and typically open source license, but there are some key legal terms that every developer and business need to be made aware of. First, commercial use. The Apache 2.0 license allows you to freely use, modify, and distribute the software or derivative works you create with it. It can be for commercial or personal purposes, it doesn't matter. Second, redistribution and attribution. This is a crucial point. If you distribute the model as is or create derivative work, you must give any other recipients of the work or derivative works a copy of this license, cause any modified files to carry prominent notices stating that you changed the files, retain in the source form of any derivative works that you distribute all copyright, patent, trademark, and attribution notices from the source form of the work. This is OpenAI, by the way. And if the work includes a notice text file as part of its distribution, then any derivative works you create must include a readable copy of this notice. And if there are no notice file, then you need to make sure it's prominently displayed into your own work. Now, what constitutes derivative work here is key. It is any work based on the licensed software in which the editorial, revision, annotation, elaborations, or other modifications represent as a whole an original work of authorship. In other words, you actually need to create something of substance for it to be considered derivative work. But the good news is you don't have to release your own work under the same terms of the Apache 2.0 license. You can actually create your own intellectual property and release it under different license terms. So ultimately, this new release creates a world of opportunity for anyone, but you just need to be mindful of the notice you need to integrate into your work. So that's it for me today. See you in the next one.